Dictation will start in 5 seconds. Get ready, start. This appeal arises from the judgment and order passed by the High Court of Judicature at Bombay dated 3/7/2015 in criminal appeal number 70/94, by which the High Court allowed the acquittal appeal filed by the state of Maharashtra and thereby set aside the judgment of the additional Sessions Judge Kolhapur dated 13/7/1993 in Sessions Case number 48/91, acquitting the appellant herein original accused for the offence punishable under sections 302 and 301 respectively of the Indian Penal Code for short the IPC. The case of the prosecution may be summarized as under: the deceased by name Lata was married to the appellant herein. A son was born in the wedlock. However, it appears that marital life was not happy. The appellant herein was entertaining a doubt in his mind as regards the chastity of his wife. One day, all of a sudden, the deceased went missing. In such circumstances, the maternal uncle of the deceased by name Yaswant Ganpati Patil, PW5, went to the house of village police Patial by name Mr. Vasant Dattu Bhosle and informed him that his niece had gone missing. It appears that on 20/10/1990 at about 9:30 p.m., PW5 brought to the notice to PW2 that his niece Lata was missing. The PW2, being the village police Patil, visited the house of the appellant herein and found that the dead body of the deceased lying in one corner of the house. The materials on record further indicate that the brother of the appellant herein by name Madhukar and his wife Lakshmi, PW4, along with their daughter Mangal, PW3, were also residing in the same house but separately in one part. Upon recovery of the dead body of the deceased, the inquest Panchanama was drawn. The body of the deceased was sent for post-mortem examination. The post-mortem examination report noted that the cause of death was asphyxia due to strangulation. It is the case of the prosecution that the appellant herein strangulated his wife to death with the help of an iron rod. This iron rod is also stated to have been discovered from the place of the incident itself by way of a discovery Panchanama drawn by the investigating officer in the presence of the Panch witnesses. The appellant was arrested in connection with the first information report that came to be lodged by the PW2 himself at the concerned police station for the offence of murder. Upon completion of investigation, the investigating officer filed charge sheet for the offence enumerated above. The case being exclusively triable by a sessions judge came to be committed to the Court of Sessions. The trial court framed charge wide order dated 20/2/1993, which reads thus: upon closure of the recording of the evidence, the further statement of the appellant herein was recorded under section 313 of the Code of Criminal Procedure 1973. The trial court, upon appreciation of the oral as well as the documentary evidence on record, came to the conclusion that the prosecution has failed to prove its case beyond reasonable doubt. The trial court accordingly acquitted the appellant herein. It may not be out of place to state that at this stage that the trial court looked into only one piece of circumstance, that is, the extrajudicial confession alleged to have been made by the appellant herein before the PW2, that is, the village police patil, in the presence of his sister-in-law. It is also important to note that Madhukar, brother of the accused, passed away during the course of trial and he could not have been examined as one of the prosecution witnesses. The trial court took the view that the extrajudicial confession alleged to have been by the appellant herein before PW2 could not be said to be admissible in evidence, being hit by Section 25 of the Indian Evidence Act. The trial court also disbelieved the discovery of the iron rod under Section 27 of the Indian Evidence Act. The state, being dissatisfied with the judgment and order of acquittal passed by the trial court, went in appeal before the High Court. The High Court reversed the acquittal and held the appellant herein guilty of the offence of murder and accordingly sentenced him to undergo life imprisonment. In such circumstances referred to above, the appellant is here before this court with the present appeal. We have heard Mr. Sachin Patil, the learned counsel, appearing for the appellant, and Mr. Aniruddha Joshi, the learned senior counsel, appearing for the respondent. State. Stop.